these motions for that minimal impact, there's no there there. And while I think there's a likely really rigorously debatable point whether that's a fair characterization, I think the principle is right. So I think one of the key questions in the context of what your objective is if you're going to use race, what do you think it's actually going to yield? On what foundation is it important that we consider race as opposed to the broader set of questions on the race-neutral alternatives that Marie suggested that you obviously consider and evaluate. That's a continuing trend. I don't think it's going away. And again, my personal view, coming from both a former department perspective and a now consulting perspective, is I'm not sure we are owning the rigor of analysis sufficiently in all cases, and we should embrace that.
Go ahead, Alan.
I think all of this needs to be put in a context that we haven't yet articulated, and that is this. Let me use the desegregation case I brought in Holyoke as an example to make 2 points. One, about what you can do without necessarily looking at race per se and to accomplish results. And secondly, where all this fits in today. In Holyoke, back in 1980, I brought a school desegregation case against the school department and the city because basically when you take a look at all the original school desegregation cases, it really mattered what resources, where you went to school in terms of what resources you had, and that's where all the intentional discrimination came about. Segregation was inherently unequal, as Brown said, and as a result, courts were saying, well, look, if you're putting money where white people are, then that's what you got to do, desegregate, so people of color could participate on an equal basis with the white population, and as long as it was equal, it didn't matter whether it was equally good or equally bad, it was just going to be equal. That was the basis of which school desegregation cases came about. If you take a look at the geography of Holyoke in 1980, you had a minority population, basically all Latino, who lived in the poor section of town which was called the Flats. If you can imagine a fan that's opened, the bottom part was where the Latino population went to school. The upper parts of the city is where the white population went to school, and guess what? Resources were different in the poorer section of town from the wealthier section of town. So the way we did it, I thought what was a creative desegregation plan, is we took the fan and we broke it into thirds, so that from the poorer section of towns fanning out in 2 different directions, you had 3 smaller fans. And what we did is we said everybody in each of the small sections of the fan, where all the elementary schools were going to be in the lower part of the city, where the poor people were, and all the upper grades were going to be in the upper part of the city, and we had busing to achieve that. And that was a way where you didn't have to say race per se was the basis of doing it, but it was geography, and geography provided the integration of Latinos and whites. Now, at the time we brought the case, the city was basically 70% white and 30% Latino. With a bit of tweaking of that case over the years, we saw something happen. The population did a flip-flop. It didn't take too many years before the Latino population was 80% and the white population was 20%. So you say to yourself, okay, within that span of time, number one, you did achieve some equity, but on the other hand, white people who could go left the city. And this basically, if you put this in perspective, Milliken v. Bradley closed the doors on metropolitan school desegregation. And as a result, who's desegregating? You have poor whites and poor blacks who are left to pay the price of what we deem to be equal educational opportunity through the concept of school desegregation. And so the kind of paradigm that was used back then isn't really relevant now. What's relevant now is the fact that 20% of all the children in public schools in the United States of America are poor. They're below the poverty level. If you take a look, there's a test that's given to high school students called the Program for International Student Assessment, called PISA. And if you take a look at the PISA scores around the world, the United States compares favorably as long as you discount 10% of the poverty. So in other words, if you only look at 10% poverty, the United States fares with Finland. Now, the poverty rate in Finland is only 4%, and everybody says how well they're doing. But the poverty rate in the United States being 20, that's why we're doing bad. So most of the schools in this country, if you're not talking about urban poor areas for the most part, they're doing quite well, thank you very much. There's no real problem in education, and we don't have to test kids through the kazoo about what they're learning when they're not getting the resources needed to learn it. But it's this 20% poverty rate that you find in a lot of areas of this country, and you can't say to those areas like the Hollyoaks or Lawrences of Massachusetts, oh, you guys go desegregate. Or what we're going to do is through No Child Left Behind, Race to the Top, we're going to test you to the hill. Well, they're not providing the resources. At the time we were dealing with Holyoke, they didn't have enough resources to implement the minimum state standards when we start talking about school finance. Once Massachusetts developed state standards, they didn't have enough resources to implement it, and we proved it in court. And yet they're tested, and if they don't pass the test, they don't get a high school diploma. That's not equity. I'll stop.
Yeah, I was at a conference last week, and somebody walked up to me from Long Island and basically raised this issue. Long Island is one of those places where you have a lot of school districts that are carved out, and essentially racial enclaves. And she asked me, "What can you do about it? What can we do about it?" And I think she was talking in terms of litigation, and I did not have a good answer for her in terms of that. And so I'm asking this panel: do any of you, how would you have answered that question?
It's not politically viable, but if you could get, like in Maryland and Florida, for example, if you have countywide systems, it doesn't deal with all of the demographic issues that you have, but it does help you. The problem is the state legislatures aren't going to go there. And so it's much easier, I can tell you, having worked in the few states that are countywide systems, it's much easier to deal with those issues, even though that's not perfect, but it'll never happen. So you don't really need a desegregation case, you just need a legislature that says this makes sense. But the problem is, especially you guys in New England, you love your little bitty towns, and you don't want to give them up. And you're saying, who is that nutcase up there, right? So I understand that. But if you've had an experience like where I live now, and I grew up in Oklahoma and Colorado, so I've lived in those little towns, But if you can see what we've accomplished, I think a lot in Maryland in particular, with the countywide systems, it really does deal with some of the issues, again, not all of them.
Okay. So I want to move on to another topic. All of you have mentioned that you have litigated, I guess all on the plaintiff's side, these school finance cases. My impression of these cases, as I said before, is generally when it's come to the liability issues, things have gone well for plaintiffs, but the difficulty has been when it's come to remedy. So we can go down this way. So we'll start with Alan in terms of talking about his experiences.
Well, I spent 23 years as co-counsel for the plaintiffs in the Massachusetts litigation. In Massachusetts, it being one of where every community has its own educational philosophy, or did until 1993. That was, you operate within the ability to operate. When I talked to the superintendent in Holyoke way back when, before our liability finding, he was saying, look, we have a philosophy of education. What we try to do is within what we can do, within our means. And they didn't have very many means, so they're asked what they were able to aspire to wasn't very much compared to some of the wealthy school districts like Wayland and Lincoln and some of the others that have, Weston, that have money galore, where money isn't an issue. So, I mean, I actually, this is during the desegregation case, I went in and I looked at a school book, a science textbook that was brand new, sitting in the classroom, didn't even have the moon landing in it. Now, that's one thing that it didn't have the moon landing when I went to school, but it's something totally different in like the mid-'80s, not to have the moon landing in a science textbook, and you can multiply this around. So what do kids learn if this is the limit of what they can learn? Well, we probably in Massachusetts have the only case in the country where we didn't have to have a trial over liability. We actually cooperated and negotiated statements of fact that went to like 500 pages of findings of agreed facts, stipulation of fact, that then went to the Supreme Judicial Court for a decision on liability. And the Supreme Court found in our favor and gave a wonderful judgment, which I have framed and hanging on my wall, about it doesn't matter whether you're rich or poor or the wealth of the community, you're entitled, these kids are entitled to equal educational opportunities, and it's the state's obligation. For the first time, it's no longer up to an individual community, it's a state's obligation to make sure that that happens. Well, that was 1993 and June 15th. 3 days later, the legislature comes to pass a law, because they didn't up until then, to deal with it by imposing state standards, to develop state standards. So you have what we call in Massachusetts curriculum frameworks. Well, curriculum frameworks are supposed to say, this is what every child in Massachusetts needs to learn, and we're going to test them on it. And moreover, if by a certain date they don't pass this test, they don't get a high school diploma. Well, to make a long story short, because 23 years was a long period of time, we waited for 7 years for the state to come up with funding. They call it a foundation budget, and let's say it's $100. A lot of these poor school districts weren't able to raise $80 or $85, while wealthier school districts could spend $150 for every on each kid. So we had to wait till 7 years till all the school districts got up to $100. And then we went back to court on a motion for further relief, and we then litigated the remedy portion. And this is where courts have difficulty because of money. We had a trial of 78 days. We had 114 witnesses, over 1,000 exhibits. The judge, who was specially appointed by the Supreme Judicial Court to try the case and make a report directly to the Supreme Judicial Court on findings, made 350 pages of findings. Every one of them was in our favor. She was amazing. She was able to recall, while taking notes on her laptop, she was able to recall on day 40 what a witness had testified to on day 5. Incredible. And she made all these findings in our favor, and then it went to the Supreme Judicial Court on argument, and the court refused to give us relief. And what the court didn't say in its opinion in denying relief was what pervaded and hung over everybody, in that you're not talking about new taxes. If you implemented her findings, you're talking about a completely different tax structure. And since the courts get their money from the legislature, and since you're talking about the legislature having to appropriate the money for poorer school districts, they ran away from it as far as they could run, but they were, in my view, disingenuous, because they never talked about the issue being money. They said the state has a plan, and therefore that's enough. I guess I would have probably been disbarred or said something I would have regretted. So what I decided to do is write about it, and I think, I don't know if you've provided it a disc. I wrote 2 law review articles, one about the whole history of the case that you can read, and the other about like what do we do now.
So what do we do now?
What do we do now? Well, it's difficult because it's going to take money. I mean, all the many wonderful things that school districts